Welcome to your annual civil rights training. At the top right of your screen, there is a resources tab for web links. At the bottom right of your screen, there are next and previous arrows to navigate the course. Throughout the training, note, TDA refers to the Texas Department of Agriculture. FNS refers to the United States Department of Agriculture, Food and Nutrition Service. Organizations refers to all organizations contracting with TDA, their sponsored sites and providers, and subrecipients. Are you ready? Go ahead and click Next. By the end of this course, you should be able to explain FNS protected bases, describe methods of assisting people with limited English proficiency, describe reasonable accommodations for people with disabilities, collect and maintain appropriate data, describe public notification purpose, select compliance review questions, identify the need to resolve non-compliance, describe good customer service standards, identify when to use conflict resolution, explain complaint filing process. This is your civil rights library. To complete this training, you will need to select a course topic. Once you have completed that topic, you'll return to this screen to select another one. Once you have reviewed all 3 topics, click Next to take the quiz. This section presents the different legislative acts that provide USDA authority for civil rights requirements. We'll also define discrimination, talk about the 6 bases protected from discrimination, and cover training requirements as well. Civil rights laws were enacted to address certain basic inequities in the legal, political, and social systems of our nation. These laws clarify the ways in which civil rights violations occur and spell out the penalties and sanctions for violations. The U.S. Congress passed numerous pieces of legislation to prohibit discrimination based on race, color, national origin, sex, disability, and age. These categories are known as protected bases. USDA implements these civil rights laws in its administration of child nutrition programs. These civil rights requirements apply to TDA, its contracting entities, and programs receiving partial or full funds. Hover over each legislative act to hear a brief but important description of it. Title VI of the Civil Rights Act of 1964 prohibits discrimination based on race, color, or national origin in programs and activities receiving federal financial assistance. Americans with Disabilities Act prohibits discrimination on the basis of disability in all services, programs, and activities provided to the public by state and local governments. Section 504 of the Rehabilitation Act of 1973 prohibits discrimination based on disability in programs or activities receiving federal financial assistance. Title IX of the Education Amendment of 1972 prohibits discrimination based on sex under any education program or activity receiving federal financial assistance. Age Discrimination Act of 1975 prohibits discrimination based on age in programs or activities receiving federal financial assistance. Title VII, CFR Parts 15, 15A, 15B, and 15C gives USDA the authority to ensure non-discrimination in all FNS programs on the basis of race, color, national origin, sex, disability, and age. What is discrimination? Discrimination is defined in FNS Instruction 113-1, page 4, as the act of distinguishing one person or group of persons from others, either intentionally by neglect or by the effect of actions or lack of actions based on race, color, national origin, age, disability, and sex. Within these 6 classes, known as protected bases, treating people differently may be considered unlawful discrimination and a basic civil rights violation. It is the policy of the USDA and FNS to provide fair and equitable treatment to every customer and employee. There are specific laws and regulations that provide for the protected bases for each nutrition assistance program. The program administered at the state level by TDA has 6 protected bases. See if you can identify which of the bases are protected. Select an icon and drag it to the box at the bottom. Once you have selected all 6 protected bases, click the check mark at the lower right-hand corner to continue. Federal law prohibits discrimination in the programs based on the protected bases shown. Select each image to learn more about discrimination for that protected base. You must select all 6 before proceeding to the next page. Age discrimination. Unfair treatment in recruitment, promotions, or granting of privileges based on the age of the recipient. For example, purposely hiring only persons under the age of 40 could be construed as age discrimination. Programs or certain parts of programs are established to assist certain groups, such as children 18 years and younger, or adults 60 years and older. This is allowed by law and is not considered to be age discrimination. National origin discrimination. Unfair treatment or bias against someone or a group of people because they appear to be from a particular country or part of the world, ethnicity or accent, or they appear to be of a certain ethnic background. Organizations that fail to provide services or deny access to program activities to individuals with limited English proficiency, LEP, may be discriminating based on national origin. Race discrimination. Unfair treatment or bias against someone or a group of people based on their race. USDA racial categories include American Indian or Alaska Native, Asian, Black or African American, Native Hawaiian or other Pacific Islander, white, including Hispanic Latino. Discerning the difference between race and color can be confusing to many. Greenwald Doherty, Counsel for Employers based in New York, provides an excellent description of race discrimination and color discrimination. The following is quoted from an article on their website, posted February 10, 2016, topic, Harassment, Discrimination, and Retaliation. Race discrimination is discrimination based on a person's race. This includes discrimination based on physical characteristics associated with race, such as skin color, hair texture, or facial features. It also includes discrimination based on cultural practices or characteristics that are associated with a particular race, and discrimination based on medical conditions that predominantly affect one race. The EEOC, Equal Employment Opportunity Commission, for example, recognizes African American, Hispanic, and Asian as different races. Disability discrimination. Unequal treatment of an individual based on that individual's real or perceived disability. Some common types of disability discrimination are denying benefits or opportunities to participate, segregating individuals with disabilities, aiding, perpetuating, or contracting with others that discriminate, failing to provide reasonable modifications. An example of unequal treatment is refusing to make a meal modification to accommodate an individual with dietary restrictions, supported by a doctor's note. Another example is a website design that is not accessible to the visually or hearing impaired. Color discrimination. Unfair or unequal treatment or bias of an individual or group of persons based on the social meanings attached to skin color. Discerning the difference between race and color can be confusing to many. Greenwald Doherty, Counsel for Employers based in New York, provides an excellent description of race discrimination and color discrimination. The following is quoted from an article on their website, posted February 10, 2016. Topic: Harassment, Discrimination, and Retaliation. Color discrimination is discrimination based on a person's skin color. Color is defined as pigmentation, complexion, or skin shade or tone. Skin color can be, but it not necessarily, a characteristic of race. Color discrimination includes discrimination based on the lightness, darkness, or other color characteristic of a person. For that reason, a person of a particular race who is dark-skinned can allege color discrimination against a person of the same race who is light-skinned. Sex discrimination. Unequal treatment on the basis of sex. For example, giving boys more food than girls at a meal service. Before beginning any program activities, and annually, all organization staff must complete civil rights training. Training is required so that people involved in all levels of administration of programs that receive federal financial assistance understand civil rights-related laws, regulations, procedures, and directives. State agencies are responsible for training local organizations. Local organizations are responsible for training their subrecipients, including frontline staff or contractors who interact with program applicants or participants, and those who supervise frontline staff. Frontline staff or contractors must be provided with civil rights training on an annual basis. Each organization should retain proof of the training. This completes the section on USDA's authority for civil rights. Click on the circling arrows to return to the Civil Rights Library. This section presents different civil rights elements that you need to be well versed in, accommodating individuals with limited English proficiency or LEP, defining disability, what personal data we collect and why it's collected, and the need for public notification. The first element we will discuss is persons with limited English proficiency, known as LEP. Persons with LEP are protected under the National Origin Protected Base. By definition, they are individuals who do not speak English as their primary language and who have a limited ability to read, speak, write, or understand English. Organizations must take reasonable steps to ensure meaningful access to their information and services. For example, if an organization located in a predominantly Spanish-speaking neighborhood is not providing applications in both English and Spanish, it may be committing a civil rights violation. Another element you need to understand is providing for reasonable accommodations for disabled persons. USDA's definition of a disabled person is a person who has a physical or mental impairment, which substantially limits one or more major life activities, has a record of such an impairment, or is regarded as having such an impairment. An impairment may be episodic or in remission, yet still be limiting. USDA provides for two basic categories of activities. Major life activities such as seeing, hearing, walking, speaking, learning, reading, eating, breathing, etc. Major bodily functions such as digestive, immune system, respiratory, circulatory, neurological, brain, etc. The organization's program, when viewed as a whole, must be accessible to and usable by people with disabilities, including those with impaired vision or hearing. Organizations are not required to make every part of existing facilities physically accessible, but they do need to ensure the Federal Nutrition Assistance Program itself is accessible and provided in the most integrated setting possible. Examples of reasonable accommodations organizations can include 1. Moving to accessible buildings. 2. Assigning aides to assist children. 3. Providing qualified sign language interpreters, large print, braille, and assistive technologies. Or 4. Changing service hours. Organizations must also make meal modification for participants with disabilities that restrict their diets, including food allergies and lactose intolerance. Organizations must obtain a medical statement to receive reimbursement for modified meals that do not meet meal pattern requirements. Every year, organizations must collect and maintain data on the races and ethnicities of all actual and potential participants. Ethnicity data indicates whether individuals are Hispanic or Latino or not Hispanic or Latino. Racial data is categorized as American Indian or Alaskan Native, Asian, Black or African American, Native Hawaiian or other Pacific Islander, or white. This information is collected to ensure compliance with USDA's non-discrimination requirements. The data allows TDA to determine how effectively organizations are reaching eligible individuals and identify areas for additional outreach. Organizations must not use visual observation to collect this data. TDA recommends asking adults, parents, or guardians to self-identify. Organizations must clearly state that participants may decline to report this information and that doing so will not affect their eligibility for meals. Explaining why the data is needed may encourage participants and families to provide it. TDA understands that requesting this information verbally may be uncomfortable, so we emphasize that respect for individual dignity should guide the process and methods of collecting ethnic and racial data. All personal information is confidential and should be protected appropriately. The names of participants must not be published, posted, or announced, except in limited circumstances such as determining or verifying eligibility for free or reduced price benefits. Participants must not be identified or separated based on their eligibility status. Organizations must establish safeguards to protect the confidentiality of this information. All organizations must include a public notification system. The purpose of this system is to inform applicants, participants, and potentially eligible persons of the program availability, program rights and responsibilities, the policy of non-discrimination, and the procedure for filing a complaint. This system must include three basic elements. The first is program availability. Organizations must inform applicants, participants, and potential participants of their rights, their responsibilities, and how to participate in the program. The second is complaint information. Organizations must inform applicants and participants of their right to file a complaint and the process for doing so. The third is the non-discrimination statement. Organizations must print this statement in full on all program-related documents and resources, including websites. When space is limited, organizations may use an abbreviated version. This institution is an equal opportunity provider. Organizations must inform the general public about FNS programs and civil rights requirements. Public notification methods must include 1. Displaying the official USDA non-discrimination poster prominently in an area where services are delivered to applicants, participants, and potential participants. This is referred to as the "And Justice for All" poster. 2. Informing potentially eligible participants and local organizations of available programs or changes to programs. 3. Providing all information, including web-based information, in alternative formats for people with disabilities and available in languages other than English, if the need exists. 4. Including the non-discrimination statement on all program-related documents and resources, as mentioned in the previous slide. 5. Conveying the message of equal opportunity in all photos or graphics used to provide program information. This completes the section on the civil rights elements of data collection and public notification. Click on the circling arrows to return to the Civil Rights Library. In this section, you'll be provided with some tools to help you avoid civil rights complaints and provide guidance for filing one. TDA will review civil rights compliance prior to an organization's application approval and during compliance reviews. Sponsoring organizations are responsible for ensuring their sites, providers, or subrecipients, including contractors, comply with all civil rights requirements. Elements that are reviewed include 1. The display of the "And Justice for All" poster. 2. Whether program materials reflect inclusiveness based on race, color, national origin, sex, age, and disability. 3. Compliance with training and documentation requirements. TDA and sponsoring organizations must require the submission of a corrective action plan if non-compliance is determined during a review. Each organization should strive to deliver federal nutritional assistance programs in a manner that maximizes customer service and provides equal access and opportunity for all. Customer service standards include communicating effectively and courteously with each other, participants and applicants, and being responsive to expressed or implied needs. These standards must be applied universally. A person's right to file a civil rights complaint can never be blocked. Many issues may be resolved, however, by using appropriate conflict resolution tools before the issue becomes a formal complaint. Developing conflict resolution skills can increase your ability to diffuse these types of issues. Any complaint related to one of the 6 protected bases is considered a civil rights complaint, and documentation of this process must be accessible at all sites or providers. All complaints must be filed within 180 days of the alleged discrimination. Complaints can be filed utilizing the USDA complaints form. Organizations must forward complaints against themselves or any of their sponsored sites, providers, subrecipients, including contractors, to USDA immediately and send copies to TDA. For Texas organizations, you may also use the complaint form available on squaremeals.org. Organizations must have procedures for processing civil rights complaints. These procedures must include how civil rights complaints are handled separately from standard program complaints and how confidentiality is maintained. It is against the law to retaliate against a person if that person has filed a civil rights complaint or participated in an investigation. This completes the Civil Rights Toolbox. Click on the circling arrows to return to the Civil Rights Library. Now that you have reviewed each of the civil rights elements, it is time to assess what you've learned. There are 12 questions to answer that are multiple choice, true, false, and multiple response. A passing score is at or above 70%. Once you have completed the assessment, follow the instructions to print your certificate.